Hey everyone, wherever you are, hope you're having a wonderful week so far. We're here with the latest episode of the Inside Crypto Show, interviews and discussions with regular people just like yourselves. Today we are joined back by Andrew Jacobson, head of legal at Do Kwon Co., former enforcement attorney at New York's top financial regulator, the NY Department of Financial Services, and blockchain regulatory attorney at Seward Kissel LLP, where he was advising on key legal issues impacting the cryptocurrency blockchain industry. If you want to go back to the previous podcast, we asked Andrew a whole bunch of questions about his background. We're not going to do that today. We want to get into all the issues that have happened. Before we get started, as a reminder, anything said by either Andrew or myself does not constitute financial or legal advice. Our opinions are our own and not to be connected with the 21.co or any of the affiliated organizations. Please, everyone, do your own research. Andrew, it has been a crazy week. I've been waking up here at town at like 6 a.m. like, oh my God, what happened while I was asleep in terms of legal issues? So for our listeners and our viewers, do you want to listen?
Yeah, thanks for having me. I think it's an understatement that a lot has happened in the past week. It could, and quite frankly, it could be the most impactful week from a legal and regulatory perspective that the industry has perhaps ever seen.
Definitely. So why don't you recap us on what's been happening?
Yeah, happy to. There's been a number of actions. I think the first action that started it all off was the SEC's settlement with Kraken, in which the SEC found that Kraken's staking as a service program essentially was an unregistered securities offering, and Kraken paid a $30 million fine to resolve that enforcement action. Later in the week and earlier this past week, there were a number of developments regarding Paxos and their BUSD stablecoin, which they partner with Binance in issuing. The first development was that, at least according to press reports, that the SEC has issued a Wells notice to Paxos. We're not exactly sure what the argument is from the SEC, but likely would be that BUSD is a security under the US securities laws. And then Paxos also received an order from the New York State Department of Financial Services mild office, essentially ordering Paxos to cease new minting BUSD due to AML concerns regarding Binance. So that really was tremendous development and something that we're following closely. There have been a number of rumors regarding the banking industry, in particular, a pretty big Wall Street Journal article following guidance from the OCC and the FDIC in the US, as well as the New York DFS, regarding concerns that banking entities are decoupling from their crypto clients over concerns regarding regulatory uncertainty, market volatility, you name it. So that's something that's really been in the press a lot. And I think lastly, we're recording this on Friday. Last night, Thursday night, Eastern time, the SEC announced finally a lawsuit against Terraform Labs regarding UST, essentially arguing that UST, was an unregistered securities offering. There was also fraud charges and a number of other aspects that I'm still working through. I've read through parts of the complaint. I haven't gotten through the full complaint yet, but I think I know enough to be dangerous at this point.
I mean, while we were chatting, just before I hit the record button, you mentioned, right, that this took a while. And why do you think it took such a long time? I know when it happened, and this was all over social media and Reddit, like, oh my God, they need to go after Terraform Labs and something needs to happen. We need to be compensated in terms of people who were affected by this. But it's taken 9 months, as you just mentioned. What do you think the reason is behind that?
I have no idea. When you look at SEC action regarding other market events like FTX and others, those happen pretty fast. You look at DOJ action regarding FTX and other players, that happened very fast. I'm not sure what took the SEC 9 months to bring suit here, if they felt there was a strong case. Putting aside the charges regarding an unregistered securities offering, maybe the SEC needed time to come up with arguments that UST was a security. There's still fraud charges that are in that complaint. SEC could have amended their complaint later. And I looked at the complaint. I always like to go to the end of an SEC complaint, or go to the end of the press release of a regulatory action and see who's working on it, how many attorneys were working on it. Now you look at the SEC complaint, now there's 10 attorneys working on this. So I'm not sure what took these 10 attorneys this long to bring the case, if it really was a priority at the agency. That to me was surprising.
I mean, they brought the complaint, Andrew, and for those a lot of people who have watched this podcast would remember Andrew, and he explains everything like very well and very nicely and easy for a lot of us to understand. Is so the complaints happened, and what is the next procedure? What's going to happen over the next 6 to 9 months?
Yeah, what happens with an SEC lawsuit, really any lawsuit, is that the complaint is filed. The defense then gets an opportunity to respond to that complaint. They can either file a motion to dismiss the complaint, they can file what's called an answer, which essentially responds to particular allegations, or they can do a number of other procedural steps, and really depends on, there's a lot of things you can do. What I think is surprising here is typically with a fraud charge like this and a high profile failing like this, there would be parallel criminal charges from the Department of Justice or some other prosecutorial agency. The DOJ has not announced charges yet here. Oftentimes the SEC will file suit. They will stay their proceeding pending a criminal proceeding. There's no indication that that's happened yet, although that could happen momentarily. So I'd look after that, quite frankly, even today or Monday or early at some point next week. And so really what could happen next is that it's not going to go fast. It's going to take time. And this is not something that you would expect to see resolved at any moment now. The fact that the SEC sued essentially means that Terraform Labs was likely not willing to accept a settlement on the terms that the SEC felt were acceptable.
Okay. And I remember going back to a previous podcast, we were talking about FTX and the Bahamas and SBF, and you mentioned like New York in particular, America was better set up to handle legal cases. And I remember reading the South Korean government was going after Terraform Labs. So in this case, I believe, and you probably know better, that their case was going to be a criminal case in South Korea. So with this case first take precedent, or again, would this be a situation where the South Korean government, being a very close ally of the United States, could say, okay, we're going to move this case and let the US Department of Justice take over?
It's a really good question. I don't know the answer. We don't know where Do Kwon is and other potential defendants in the case. We don't know if they're located in a jurisdiction that has an extradition treaty with the US or South Korea. So I think this one, from a diplomacy perspective, probably will be very sensitive. There's nothing stopping multiple countries from bringing multiple criminal actions and letting it settle out that way. And yeah, I think a lot depends on where he is right now. The US Department of Justice has a lot of experience bringing these cases. The government of South Korea might say, you know what, let the US spend the resources doing this. Let the US court system deal with this guy. We don't want to deal with it. And so I'm not really quite sure how it will play out. I don't think anybody is, but you look at the FTX situation with SBF. My view, this is my personal view, was that the Bahamas wanted to get rid of this guy. They didn't want to deal with the circus. They wanted to move on. Let him go get tried in the US. The Bahamas can bring their own charges later on or on a parallel track. That's not really stopping them from doing that because the US has an extradition treaty with the Bahamas as well. And so it's a really good question. I don't know how this one's going to play out, though, regarding Terraform Labs.
That's no problem. I think that answer is good enough for a lot of people. Andrew, talking about going back to Kraken and their settlement with the SEC, and most people who are on crypto Twitter would have seen Brian Armstrong's tweet from Coinbase, hey, staking in the US might be in trouble, and people's hearts stopping. And even if you're not in America, oh my God, because no matter where you are, yeah, this could happen in my country next. But Kraken settled, and I remember the chief of legal of Coinbase, Paul Gurowal, I'm not pronouncing his last name right, but he was like, okay, this is why staking is not an issue. And they referenced the Howey rule. And again, you've talked about some of this on the analyst call this week, which I would encourage people to check out. The YouTube link will be down in the podcast is YouTube, as well as the podcast, the audio version as well. But yeah, he said this is not what it is. And they would step up to base and they would defend this in court. What do you think about that?
Yeah, I think staking itself, I think, is clearly not a security, even under the US standards. I think staking as a service after the Kraken settlement, is there an argument that it's a security? Potentially. I think it's likely not, though. And I think Coinbase has pretty strong arguments, quite frankly. And I saw their posts and I saw their Twitter feed regarding that topic. I think the real challenge with the Kraken case was, how was their staking as a service program structured? The SEC found that they pooled assets, there was a liquidity reserve, that Kraken had a certain degree of discretion in allocating customer assets for the staking service. I think that's what kind of drew it closer to the line. If Kraken had fought this, if they had not settled, could they have won? I think there's a decent chance they could have won, arguing that it was not an investment contract, which employs the Howey test, or a note, which implies the Reeves test under US federal securities laws, I think there really were arguments that it wasn't a security. But I think staking as a service, I don't think it's dead in the water under US or really any other mature jurisdictions laws. I think the real keys to look out for are, how do you distinguish staking as a service from, let's say, an earn type program? A centralized intermediary is taking your assets and making decisions on your behalf. With staking as a service, there's no decision. You allocate it to the node that validates transactions, and in return, you get rewards. You take a cut of those rewards to cover the costs of running the nodes and other services and other fees, and then you give the rest back to the holder. I think there's a pretty strong argument that's not an investment contract, and that's not a security. At some point, somebody will fight the SEC. I think there's a reason why you haven't seen the SEC go after the big staking as a service providers yet, because I think their case is a lot weaker, and there's, quite frankly, significantly less risk. This is my personal view. There's a lot less risk with staking as a service, true staking as a service, where the tokens are allocated to operating the node, compared to an earned product in which your funds can be lent out, they can be invested in various ways. Staking as a service, the main risk, as far as I understand it, is a technological risk. It's the operation of the blockchain network. And if there are slashing penalties, if there's a failure of the network, that's really how it could be impacted. I think that, to me, was, I think, very upsetting for those in the industry, because, staking as a service is really fundamental to operating an efficient blockchain network. And so it's a really good question. And it's something that I'm interested to see how it will play out over the coming months.
Andrew, from what you're saying, like, in part, and of course, as always, you can correct me if I'm wrong, is that what's happened with staking as a service, or staking in general for some companies, is that maybe legally and physically they were structured wrong, which is why they're like, okay, we don't want to fight this, because a lot of crypto companies were operating in the Wild West. And again, we talked about that before. If moving forward, right, will companies just have to be more careful, structure things more carefully, speak to crypto experienced lawyers like yourself in much more detail, and be transparent on their websites and other programs?
It's a really good question. I don't think Kraken did anything wrong. I think the challenge in the US and other jurisdictions from a regulatory perspective is that there's just not clear guidance. The SEC never gave guidance whether staking as a service was a security. The SEC, the charges in that settlement with Kraken were that Kraken engaged in unregistered securities offering. There was no guidance of what staking as a service, how it could qualify as a securities offering. And even if it did qualify, there was no opportunity, no meaningful opportunity to register that offering with the SEC. And at some point here, you have this challenge where regulators won't tell you what's unlawful. They keep you in what I refer to as a regulatory gray area. And then on the other hand, the enforcement arm of the government really takes advantage of that lack of clarity and will really step in and bring an enforcement action. And so I don't know that talking to more lawyers would have helped. In the crypto legal space, you're going to get 10 different opinions from 10 different crypto lawyers, and all of them are right. And so I don't think it's a matter of them taking more precautions. I think it's really a matter of regulators and the government need to provide more clarity, unified clarity, and provide a meaningful opportunity to register these products if, in fact, they are securities.
Okay. So, I mean, I told people we're going to do an episode with you, and you developed quite a few fans from the last podcast. So I think one of the questions, and again, we're not political, is people felt like the current US administration was exerting power from top down, forcing the hand of the SEC, forcing the hand of the New York Department of Finance. Yes, to say, okay, you guys need to stop going at 60 miles an hour, hit the crypto companies and regulations hard, start providing clarity, because there was just too many things that happened in 2022. Do you think that was the case, or are people just overreach?
I don't know. I think there's a lot of discussion whether this recent crackdown is coordinated amongst various US government agencies. It very well could be. I actually don't think it is. I think there's some loose coordination. I think the agencies in the US are not planning as much as we all think they are behind the scenes. Certainly when I was in government, we would, work with other agencies and cooperate, but on really high profile cases, you'd be surprised that they're not as synced up as you maybe think they are. And at least this is my personal view, is that the agencies, quite frankly, are actually competing against each other, not cooperating. as much right now. And so what does that mean? I think that means that when one agency does something, the other agency feels a need to step in and outdo them. And then when that agency outdoes them, another agency steps up and says, hey, I want to be the face of this. And so I think that regulators, quite frankly, probably realized they should have done more pre-FTX, pre-Celsius, pre-Voyager, you name it, Luna, UST. I think that they realized they should have done more. I think that they realized that they don't want to be caught flat-footed now. And so perhaps there's an overreaction, which is never a good thing. And yeah, I'm pleased that I have fans out there, but quite frankly, on this one, I don't have a straight answer.
There are a lot more fans. I think it was like 7 questions, all just on that previous question was just variations of that. People tend to be conspiratorial sometimes. But Andrew, you touched on a really good point. And I had seen that narrative this week in a bunch of different articles, even here in Taiwan as well. The idea of unbanking crypto companies, deconnecting them from traditional banking institutions. What's your take on that? Is this going to accelerate? Are crypto companies going to have to search for another solution? Are there still going to be some banks who say, yes, we can help you? I mean, how's that all going to work out?
Yeah, it's a really good question. I think that there were a number of banks over the past, let's say, 2 or 3 years that really took advantage of a niche in the market, which was that the crypto industry was largely unbanked. It had a very hard time accessing fiat currency and just getting reliable bank services. Bank allows you not just to get fiat, it allows you to store assets, get FDIC insurance for dollar deposits. It allows you to make payroll. It allows you to essentially run your business beyond simply converting crypto to USD or crypto to other fiat currencies. I think that there were a number of banks, in hindsight, they probably took on, I don't think too many crypto clients, but probably did not do as well of a job as they would have liked to ensure that their deposits were properly diversified. And there's been guidance from the OCC, which is a federal banking regulator, and the FDIC, which provides FDIC insurance, as well as the New York DFS, which is the New York banking regulator, and some other regulators have issued guidance as well, essentially requiring that their regulated banks really do a better job on performing risk analyses for crypto clients. That's what the text of the guidance says. How has that been implemented? I think the way that's been implemented, quite frankly, is that a number of banks have started debankling and decoupling from the crypto industry. You look at some of the big ones. What are the big ones? There was a big Wall Street Journal article regarding a Signature Bank, Silvergate Bank, which as well. And Signature, according to this public article, was pretty keen to take down the percentage of deposits that are allocated to crypto customers from, I think, 25 or 30% to about 15%. And other banks are doing the same. And although there are other banks that are taking on more crypto companies as depositors, and what does that mean? I think that's a big challenge for the industry. I think that there's been a big focus from governments to keep crypto out of the traditional financial system. The one thing I will say is that not all crypto companies are created equal, and not all deposits at a bank are created equal. So if you have a company that, is a stablecoin issuer or is an issuer of assets that need massive liquidity, I'm talking billions of dollars of fiat or fiat equivalent liquidity within hours, that poses a different safety and soundness risk to a bank than a crypto company that just needs to make payroll. Like, that's different. And so I think that banks are probably looking at this much too narrow and should really adjust their risk ratings based on the business of the customer, the nature of the assets that are under custody with the bank. Are these assets highly liquid, or are these assets largely stable and going to stick around, meaning these deposits? And my hope is that banks don't pull away from the industry. I don't think they will. I just think there's a reckoning now on how to assess risk, quite frankly.
Yeah, it's very interesting you mentioned the assessment of risk, because one of the things I was looking at was just an article from CoinDesk, which is about, I guess, EU rules for crypto, and how they said, like you were saying, yeah, you have to give crypto companies maximum risk weighting. I'm like, yeah. Wow, that is going to make things difficult. Do you think the US will eventually go down this route? I mean, or is that appropriate, you think, from the EU? Does that create regulatory clarity, saying these companies need to have maximum risk and now you can deal with them? How does that work?
I think anytime a regulator puts out a blanket statement that one particular customer in one particular industry is high risk, I think that's a challenge. You could argue that those in the gambling industry traditionally, or those in the legal medical marijuana industry, whatever you want to call it, are higher risk simply because those industries have been historically rife with money laundering and exposure to risk. I don't think the crypto industry has that problem. You look at studies from Chainalysis, and the degree of crypto volume that's criminal is under 1%. It's much easier to launder fiat currency, to launder objects like cars and etc., real estate, than it quite frankly is to launder crypto assets that are very easily traceable on chain, for which the intermediaries are subject to the Bank Secrecy Act and other AML laws. I think that government coming in and dictating the risk rating of a particular customer, I don't think that's not how bank or regulatory risk ratings have ever worked. Ultimately, it's on the bank itself to do that, because the banks are empowered from a risk perspective to make their own risk judgments.
Exactly. I totally agree with you. Andrew, on a personal note, I know we had a listener who listened to you last time. He's studying law in the States. I don't remember where he said, and he wants to be a crypto lawyer. And he was wondering, like, how are you, given everything that's happening this week, how are you preparing? How are you dealing with all of these issues? How are you getting ready for whatever's going to happen over the next 6 months as a lawyer for 21 Co and 21 Shares, but on a personal level, getting ready knowledge-wise?
Yeah, it's a really good question. I get this question a lot, and I've been practicing law over a decade and doing crypto work for, I'd say, about 6 or 7 years now. The question that I get is, how do you be a crypto lawyer? And I think the best way to be a crypto lawyer is, one, is understand the technology. And then two, it's really study the laws. You need to have an underlying expertise in a number of areas of law to really be in this space. So know the securities laws, know the AML sanctions laws, be knowledgeable about IP issues such as trademark and copyright, know banking laws. You don't have to be an expert in every area, but if you can pick one or two that you're really good at initially, get an expertise from there, branch out, and you can learn a little bit more about everything. But I think that the most important thing is, just in terms of keeping up with recent developments, is just reading what comes out. If the SEC issues a complaint, go read the complaint and then read the commentary on that complaint. The OCC or the FDIC issue guidance, take a moment, read that guidance. I always mentor younger lawyers and say, listen, nobody's going to give you a specialty. Nobody's going to teach you the skills that you need to progress in your career. It's really on you to take the time after work hours, on a weekend, take that time to learn and develop and hone your craft. So, Korean, it's a great question, and it's challenging. Every week there's something new, but that's what keeps us going. Is if there wasn't something new, then we would just be too comfortable, and that's not good. We don't need to be too comfortable.
So to sum it, like, you've just been doing a lot of reading, a lot of social media, a lot of keeping up on things, and I guess that's what a lot of people have to do. You particularly this week and last week, taking a step back, right? A lot of regulation has come out, a lot of precedents, a lot of commentary. What do you think the regulatory priorities are for the US and, broadly speaking, globally? Because the US regulations on crypto do impact a lot of US friendly countries like Taiwan, like South Korea, like Japan. So what do you think is going to happen this year as far as that goes?
Good question. I think there's a number of areas. One is the refinement and the clarity regarding securities laws in the US. What's the securities offering? I think that'll be probably the most important question that comes out. Will the SEC provide guidance, or will they continue to bring enforcement actions from which guidance can be inferred? My hope is they do the former, issue real meaningful guidance. Last time they really did that was 2019, and they actually only issued guidance under what qualifies as an investment contract, which is the Howey test, not other theories for what could be a security. I think that's one area to watch. I think there'll be a real tension between prudential regulators. Think of bank regulators. Think of those that are on the supervisory side performing examinations versus those on the enforcement side and the prosecutorial side. I think that tension is something that I'm watching very closely. And I think a challenge could be that enforcement is dictating what's a supervisory priority, and the supervisory side is jumping more into enforcement via supervision. And so that's something that I think is something to look out for both in the US and abroad. And then I think lastly, what's the status of intermediaries? There are a number of intermediaries that are regulated, particularly in the US. There are a number of intermediaries regulated in Europe that have the licenses they need to have to do what they want to do. Is that enough? Is that enough for government, that those intermediaries who help facilitate the transmission of funds, help facilitate the exchange of funds, help custody assets. Are those companies under the correct regulatory regimes that the governments feel they should be? And so I think those 3 or 4 areas are ones that I'm watching really closely. But you look back at the history of the regulatory environment for crypto, there has been an up and down. There's been an ebb and flow from fraud and rug pull cases early on, ICO cases. And you had a pretty quiet period before crypto winter during the bull market. There just, quite frankly, wasn't much going on. Now you have the bear market, crypto winter, you have a number of enforcement actions. Things are really coming to a head. And so I'd say from a regulatory perspective, right now is the most serious it's ever been. The market's the most mature it's ever been. The industry and companies are the most mature and responsible that they've ever been. And something has to come. And my hope is that there's unified clarity, a unified regulatory framework. Europe is already pressing ahead with MiCA. It has its pros and cons, but at least it's something. My hope is the US follows in their suit.
You brought up a really good point, custody of assets. And this is something like when we were preparing for this show, we were talking about that. I'm like, yeah, that's really makes sense. The 21 Shares research team has the dashboard where you can see how assets are custody, stablecoins and stablecoin volumes and inflows and outflows in different exchanges. And I think we saw something today, which was about the CEO of Binance had a backdoor to some bank account and moved $400 million to a company that he now owns. And so custody is a very important issue. And what's your take on custody and some of the stories around it this week?
Yeah, custody could be the most important issue in our industry. What it really comes down to is trust. Do you trust someone else to hold your assets? I think that, quite frankly, is the most important aspect of our industry. And I think that the big players have done a good job. I think that there has been some lack of trust around certain entities out there. Really comes down to transparency, reliability, and predictability. Do you know where your assets are? Do you know reliability that your assets will be safe from cyber attack, from failure, from insolvency? And then predictability. Do you know that your assets can be pulled off at any time? Do you have liquidity? So yeah, there's been a lot going on the custody side. There was a proposed rule from the SEC this week regarding the custody rule, which is under the US securities laws. And there's really a question of where SEC registered investment advisors can custody customer assets. Can they do it with state chartered trust companies? Can they do it with BIT license holders in New York? Or do they have to do it with nationally and federally chartered banks? That proposed rule will receive thousands of comments likely. And so we'll see where it goes, but it's a really great point, Korean, that custody in our industry is, quite frankly, probably one of the most important issues.
I remember on the previous podcast, you were saying maybe 2023 might get some clarity looking at everything that's happened this week. Are we going to hold you to this year having some clarity, or should we wait for 2024, maybe 2025?
You know what? It's only February in 2023, so it's early. Will there be clarity? I don't know. I think that banking regulators have issued guidance in 2023, so they were off the hook. I'd like to see some clarity from other regulators. So I'm optimistic. So I'm going to say yes, there will be clarity. That's my personal prediction, although I can't guarantee it. I think there clearly will be significant enforcement, and from that, we can infer a lot. But in terms of real guidance, real new legislation, I think it's maybe 50-50 chance.
Okay. I think one thing we're going to have to mention, I think I'll get persecuted if I don't talk about it. Hopefully people go and listen to the full conversation you had on the research analyst call about Paxos and BUSD, and maybe let's take this a step further because you already had all of this discussion already. So, no BUSD potentially in February 2024, by the time people like me, because most Taiwanese people are Binance customers here, and that means more people using Tether, more people using Circle. And I remember reading a story, it was like Circle got Paxos or Binance in trouble with BUSD. How do you think that's all going to play out? Are these stablecoin companies going to go after each other? Is this a competitive thing? Is this a legal thing? People always say stablecoins are always going to be there. They're safe, they're stable, they're collateralized. BUSD was collateralized. What's going to happen there?
I don't know. I don't know what's going to happen. I think that the argument that collateralized stablecoins is a security, I think it's a challenging argument. I think it's one that the SEC would have a pretty good chance at losing. And so my hope, this is my personal hope, is that if the SEC does bring suit against other legitimate stablecoin providers, that they would fight and that they would get a real court ruling that these are not securities. No one buys a stablecoin, a collateralized one, for investment purposes. They buy to do other things in the industry, like access trading platforms, access faster settlement, you name it. I don't know how it will play out. I think that there are differences between certain types of stablecoins in terms of reliability. The big players out there, maybe I'll take a step back. What is the goal of US authorities here? We've seen a big jump in volume and AUM to Tether compared to US issued stablecoins. How does that help the US? If, quite frankly, I think it doesn't help the US, particularly from a national security perspective. This is something I mentioned on the analyst call. US stablecoin issuers, the collateralized ones, have the ability to do what are called freeze and seize. And so to the extent they get an order from the government or they notice criminal activity on chain, they can freeze that stablecoin asset in a foreign wallet. Now, that's a tremendous benefit to the US from a national security perspective. The idea that the US would push all of those assets, you could call them under management, whatever, market cap, whatever you want to call it, the idea they would push that overseas, that doesn't really make sense to me. So I don't know how this will play out. My hope is that the US, instead of pushing stablecoin issuers away, would actually bring them in, pass legislation, make them clear what their status is, and let them flourish under government supervision. I think they would be more than happy to take that route rather than live in this gray area where they don't know what's going to come out the chute in 2 weeks, 3 weeks, you name it. So that's where I see things going, but your guess is as good as mine.
I never know what I'm going to guess, but yeah, Andrew, you've taken up a lot of your time. I really want to give you a chance because you always have really cool opinions. You always say really good things internally on Slack calls and all hands and that sort of stuff. So I want to give you this last minute or few minutes, right? Anything you want to end off with, any commentary you want to make about some of the issues, anything on the top of your mind, whatever you want to say, the floor is yours to end off today's podcast.
Yeah, I appreciate it, Krina. It was a pleasure being here. I think the thing I would end on is what is most important for this industry from a legal regulatory perspective is clarity and predictability. People need to know what laws they're subject to, and they need to know how government will enforce those laws. You look at every law in every mature democratic jurisdiction, you want to know how it will be enforced, and you want to know who it applies to and how it applies. I think for the industry to truly take that next step and be more mature than it already is, the government has to help in that regard. And my hope is that in 2023, that is the theme. Will it be? I don't know, but that's really my hope from a legal and regulatory perspective.
And that's something I'm going to hope for as well, because clarity just means everything's easier for everybody, less heart attacks when you wake up and look at Twitter in the morning. Andrew, thank you so much for, again, doing another episode. And for those who are watching all the way to the end, yeah, Andrew's offered to do another one soon. So hopefully, I'm very sure we're probably going to have to do another one soon, given everything that's happening. Andrew's socials, as usual, his LinkedIn, his Twitter will be there. You should definitely follow those. The company's LinkedIn, the previous podcast, and the analyst call will be there. So there's lots of things because Andrew said a lot of really cool, really interesting stuff. The YouTube shorts are on YouTube and on TikTok as well. If you're on either of those platforms, have a look at those. Those are also really cool. And Andrew, hopefully we can talk again in a few months rather than like in a few weeks if something else happens. So I'm going to keep my fingers crossed for that.
That sounds great. Happy to talk anytime. It was such a pleasure speaking and happy to be here and look forward to being here next time.
For sure. And thank you again.